verdict today, I'm going to give him 5 days in jail. This isn't conduct's outrageous. You walked out of the bar with a glass. You're very drunk, 286. I don't know if you drank it all in there. They shouldn't have served you that much alcohol. They're talking to your wife. You're over barfing out the window of your car. You didn't log in for any of these sentences. That last one was an ordinance case. But this is a misdemeanor matter that would charge assault and battery and malicious destruction of property. The defendant's name is Mark Andrew White. The file number is 241244. It's here with his lawyer, Luke Knopfinger. This was a plea with an offer of deferral, and I don't want to do a deferral in this case. It was an offer. The first offer was malicious destruction of property. The defendant declined. It was set for a last pretrial on 10/10. Then the offer was assault and battery with the deferral and restitution. There is no domestic violence deferral for assault and battery. There is a delayed sentence. I have to look at my notes and see what was discussed at the time of the plea. Plea assault and battery with deferral and restitution. Dismiss domestic violence. Don't dismiss till the time of the sentence. Dismiss the MDOP charge. Eyeglasses. I need victim input, police report, and restitution figure. I don't think I got any of those things. I got the police reports. I didn't get any victim input. I didn't get an estimate on the amount of the glasses. And the defendant was trespassed from South Lane's bowling alley. Mr. Knopfinger, what would you like me to know?
A couple things, Judge. We were anticipating taking benefit of the deferral probation.
Well, I probably wouldn't have taken the plea if I should have told him then. Wish Mr. Rogness was here. But I guess if I wasn't going to do it, I should have told him then rather than now. So let me hear your elocution.
Yeah, and we're open to alternatives that the court's going to propose. One, Mr. White has given up alcohol since the day of this incident. The court remembers the factual basis here. This was over a glass that he'd taken out of his bowling alley, and he expresses remorse for how he conducted himself that day and recognizes that alcohol was a contributing factor. He was arrested. He was taken to the station. He was able to post bond. I'd also note, too, Judge, that there was another case, 24-1468, that was dismissed as a part of the plea deal. He was arrested and spent a night in jail in that case, too, even though maybe not statutorily entitled to jail credit. That's the court to consider it. Like I mentioned, he's given up alcohol. He's agreeable to a term of probation, which could include anger management. We talked about that. He's expecting a child come December. He is open to any restitution. Understand the court doesn't have a request. The court can leave that open. He did want to apologize to the victim. So with all that being said, Judge, we were anticipating taking advantage of deferral if that's not legally possible.
Well, because deferral, if I delay the sentence, there's no domestic violence deferral, but there would be a deferral as in a delayed sentence with conditions. And if he completes the condition, the prosecutor would dismiss the charge. Since Mr. Rogness has come, we've dealt with several of these.
Could I confer with Mr. White for just a moment, Judge?
Yes. So what that would be is the sentence would be set out for 6 months. The things that you're proposing, like anger management and restitution, would be done in those 6 months. And if it's completed, then the charge would be dismissed. If it isn't completed or the wheels fall off, then he's subject to sentence on the assault and battery charge.
Did you say that one more time? I'm sorry. What will I have to do within the 6 months?
You'd have to do the anger management class, no drugs and no alcohol, and pay restitution for the glass and her eyeglasses.
Okay.
If Mr. White's biggest concern is he would like to take care of the case today. He understands the deferral. It's okay if it remains on his record. His biggest concern is jail time. So,
Well, if he takes care of it today, I'm going to give him 5 days in jail. This isn't conduct's outrageous. You walked out of the bar with a glass. You're very drunk, 286. I don't know if you drank it all in there. They shouldn't have served you that much alcohol. They're talking to your wife. You're over barfing out the window of your car. You slapped this lady in the face, which witnesses saw. Her glasses are $130 and $10 for the glass. So if you want me to sentence you today, I'm going to give you 5 days in jail in addition to the one you did, 6 days right now, and $140 worth of restitution. If you want to do the deferred sentence, I'll set it out for 6 months and we'll do the other things that we discussed.
5 days.
All right. I'll be off your back. Other than what I just said to you, did anybody promise you anything to get you to plead to that?
No.
Or alter your plea or threaten you?
No.
Six days credit one, leaving 5 days to serve. I'm gonna waive the fine. You got a new baby coming. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, $140 restitution to South Liens. And Margaret Johnson. Which is that? $365. You had enough money to pay a bonding company $500 to get out. Let's see if I got any money here. You did go to jail in another case where you assaulted your mother.
Yes.
So I gave you one. I didn't because that's not this case.
Do I get 4 days or no?
No, you get 5. That's how many years.
Sorry, just thought I'd ask.
Well, I guess I would too.
That's not really my wife.
Again, the bond was by a bonding company. I'm going to give you till the end of the year, 12/31/24. $365. I waived the fine. It includes the restitution, the state minimum fees, and your attorney fee. Mr. White, I hope you can put the alcohol down. Right now, you're just holding your breath. You need to go to AA or support group or something to just say, I'm not going to drink. Eventually that balloon bursts and you get sucked back in unless you get some help. All right, you're good to go.
What's the charge again, sir?
Assault and battery.
Yeah.
You're probably going to go on.
No, I fell. Where am I watching? In my wallet. Today looked like one day and then
Yep. You might even get a day of good
What unfolded in this courtroom wasn't just a sentencing hearing. It was a stark lesson in how alcohol, impulse, and accountability collide in the justice system. The defendant, Mark Andrew White, stood before the judge facing serious misdemeanor charges, assault and battery, and malicious destruction of property. What initially appeared to be a plea deal with the possibility of deferral quickly took a sharp turn. The judge made it clear right away that he was not comfortable granting a deferral in this case, calling the defendant's behavior outright outrageous. The court reviewed the facts. They were not flattering. Mr. White left a bowling alley extremely intoxicated, carrying a glass outside. His blood alcohol level was reported at 286, more than 3 times the legal limit. Witnesses described him vomiting out of his car window while police spoke to his wife. Things escalated further when he slapped a woman in the face, breaking her glasses. This wasn't just reckless behavior, it crossed into violence. His attorney tried to mitigate the damage, explaining that Mr. White had stopped drinking since the incident, expressed genuine remorse, and was open to anger management and probation. The defense also highlighted personal factors: a baby on the way, willingness to pay restitution, and a desire to resolve the case immediately to avoid further disruption to his life. The judge then laid out 2 stark options. The first was a delayed sentence, 6 months of compliance, no alcohol, anger management, and restitution, with the possibility of dismissal if everything went perfectly. The second option was immediate accountability, jail time, restitution, and closure. When the defendant made it clear that avoiding jail was his top concern and that he wanted the case resolved that day, the judge delivered a firm response. If Mr. White wanted finality, the court would impose 5 additional days in jail on top of time already served, along with restitution for the damaged property. No deferral, no waiting, no safety net. The judge didn't mince words. He criticized the bar for over-serving but placed responsibility squarely where it belonged, on the defendant. Alcohol, the judge warned, isn't just something you white-knuckle through. Without real support, relapse is often inevitable. The message was clear. This wasn't just punishment, it was a warning. Ultimately, Mr. White accepted the sentence. The court credited prior jail time, waived fines in light of his growing family, ordered restitution, and gave him time to pay. It was tough, but measured. Accountability without cruelty. The takeaway from this case is powerful. Courts will consider remorse, change, personal circumstances, but violent conduct fueled by extreme intoxication will not be brushed aside. Sometimes the justice system offers grace. Other times, it demands consequences. So here's the question for you. Did the judge strike the right balance between punishment and rehabilitation? Or should deferral still be an option when someone shows change after the fact? Let us know what you think in the comments. If this breakdown helped you understand how sentencing decisions really work, hit like, share this video, and subscribe for more real courtroom moments where choices have real consequences.